Okay, live stream is on.
It's working. Mhm.
I'll admit everybody. And recording. All right. Good afternoon, everybody. And thank you all for joining us for today's month of service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I work as the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration, which is also known as AMOS. Also included in our partnership, we have the City of Houston's Department of Neighborhoods. We have our presenting partner on behalf of the Texas Legal Services Center. We have Ms. Lisa Nelson. We have Ms. Mabel Menifee on behalf of the Harris Central Appraisal District. On behalf of the Harris County Tax Office, we have Ms. Angela Urbanowitz.
Yes, Urbanowitz.
Okay, I said that correctly. We also have Lone Star Legal Aid, the Earl Carl Institute, the Harris County Attorney's Office, and Houston Volunteer Lawyers. And together we make up a month of service. And basically a month of service is the collaboration of all of our organizations coming together on a monthly basis. We offer a variety of different workshops, resources, and information to the community relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. We decided to collaborate several years ago in an effort to create a larger impact and coming together and pooling a lot of our initiatives so that we can get as much information out to the community as we possibly can. And it actually is funny that we're here today because when we used to do these sessions in person, and we were actually here at this church when COVID happened, and we completely stopped doing all of the everything in person. So we're now trying to kind of get back out there. For those folks on Zoom, sorry, you guys don't know that we are live and on Zoom and here in person. Today I am at the Trinity Gardens Church of Christ. They have graciously allowed us to host to be here so that we can present information that are for the folks that actually live in the community that may not necessarily have the technical capabilities or don't know how to, use Zoom or what have you. So that we can actually get questions addressed and answered and information out to the folks that are here in person as well. So, but yeah, we used to do these sessions in person. They have evolved over the last several years to include more information. This particular session is kind of like the part two, not necessarily part two, but the second part of what happens after someone passes away. When the first part that we do, the first Thursday of each month is the wills and estate planning session. That's what happens once before you pass. What it is that you need to have in place, what you need to do in order to make sure that your assets are protected and that it goes to whoever you need it to go to. This session is more what happens after someone passes. You inherit their property. What happens if they owe property taxes? What happens? Oh, that's yeah. Oh, what happens if they owe property taxes? If they've got probate concerns, what that probate process is like. Because a lot of folks sometimes don't realize that there's a step, there's something else that needs to be done after someone actually passes away. You don't just automatically inherit the property. There's other things that need to be done. So we're going to be going over all that information for you all today. And for that purpose, we also included the Harris Central Appraisal District to talk about different exemptions that are available for heirs that are out there. And she's going to get into a lot of details about other things that are offered and what's available as far as the exemptions go, as well as what happens if they owe the property taxes. We have the tax office that's going to be kind of talking about what that process is like and how they do the bills and when those bills are due after someone passes and so on and so forth, and the arrangements that can be made for that. But just so you do know, we do a property tax presentation with the Central Appraisal District as well as the tax office the fourth Thursday of every other month. So April, I believe it's the 22nd, Ms. Mabel, is that correct? Because I don't have it in front of me. I believe it's April the 22nd is when we're going to get into that presentation, when we get into a lot of details on Zoom. It's going to be on Zoom. But we're not going to get into a lot of detail or questions asking about protests and things like that at this session. So that is a completely different session. So just want to make sure everybody knows that. But also included in your packet, there is a schedule of where the HCAT is going to be doing their in-person sessions as well. For the folks on Zoom, I'll be emailing that out to everybody so that you'll have that list available to you as well. But the information that is presented here today, it is not for legal advice. We are here to provide information for you, educational purposes only. However, we do encourage you all to reach out to our legal service partners, like Texas Legal Services Center, Lone Star Legal Aid, Earl Carl Institute, and Houston Volunteer Lawyers for more one-on-one or personal detail and apply for their services. This is an opportunity for you to ask the questions that it is that you have, but do know that we ask that you try to keep your questions to be as general as you possibly can. One, we're here live in person as well as on Zoom, and we also broadcast on our social media platforms live. So we want to try to protect your privacy as best as we possibly can. So we don't want to divulge any personal detailed information. You live at so-and-so, you were married to whoever, you have X amount of kids, and we don't want to get into that level of detail with your questions. So try to keep your questions as general as you possibly can. So what else is there? So if you do have questions, you're joining us on Zoom, please feel free to type your question into the chat and we'll make sure they get addressed at the end of the presentation. If you are joining us on our social media channels, I am actually monitoring that as well. So feel free to type your questions into the comment section. I know that there were a couple of questions that were emailed to me in advance. We do have people here that are in attendance today. So if you guys do have questions, please feel free to just raise your hand and I'll make sure that I relay the question to the presenter so that your questions can get addressed as well. So again, there's a lot of information that's going to be covered here today. There's going to be a lot of questions. So without further ado, we're going to go ahead and introduce our partners, our presenters, and we're going to go ahead and get started here. So Cecile, why don't we have you introduce first? And Ms. Mabel, we'll have you and Angela introduce yourselves, and then Ms. Lisa, we can introduce yourself, and then we'll roll right on into your presentation.
Thank you so much, Nia. Good afternoon, everybody. My name is Cecile Carlson. I'm the Outreach Coordinator here at the Department of Neighborhoods. And like Nia mentioned, we are one of the partners in the Month of Service Partnership. Very thankful to everybody that's logged on today, including our speakers. Thank you so much for being here, and I'm looking forward for today's workshop.
I guess I'll go next. Good afternoon, everyone. My name is Mabel Menifee. I'm with the Harris Central Appraisal District, and I'm pleased to be here to sort of follow up on some information as Lisa's going to give you a really beneficial presentation, broad, wide-ranging presentation on clearing title on inherited property. A lot of questions tend to come up about the property tax piece of that, the exemptions, etc. So I'm going to follow her with some additional information on that just to sort of help you fill in the lines, fill in the blanks about the process. So I look forward to talking with you soon.
Okay. Did Angela introduce herself? Angela, you there?
Yes, I'm here. Sorry.
Okay, that's okay. Go ahead and introduce yourself really quick.
Hi, my name is Angela Urbanowitz. I'm from Harris County Tax Office.
Ms. Lisa?
Good afternoon, everybody, and welcome back to those I met last month at the Todd Clinic. I apologize for not being able to be there in person with you today. My name is Lisa Nelson. I'm a staff attorney with Texas Legal Services Center. It's a statewide organization located, excuse me, in Austin. I am here in Houston. And I am here to give you an overview of the probate process because you were all here last week and are getting your estate plans in place, and I'll explain to you how they're used. But we have a special focus on how to clear title to inherited property because that's a big issue I was going to say in Harris County, but really in the state. So, do I have my screen share correct?
Swap view.
Okay. I didn't even change it from the last time.
Good to go.
Thank you. So I'm here to talk about clearing title and other probate concerns. I will be available at the end of the presentation to answer any questions that you have. And hopefully you'll learn a lot today. So I'm going to talk about the probate overview, excuse me, how to clear title to inherited property. And I always like to say, let's make sure that this problem doesn't continue into the future. Let's talk about how to be able to transfer property easily and inexpensively to your heirs. And then I'll pass it over to the partners at Harris Central Appraisal District and the Harris County Tax Office. I'm with Texas Legal Services Center, which was founded in 1981. We have more than 10 practice areas that touch almost every aspect of civil law that impacts low-income Texans. And we're here to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. I will also put my contact information in the chat later during the presentation. So let's give my probate 101 very quickly. There's a lot of vocabulary that you learn when you're dealing with probate cases. The decedent is the person who has passed away. If they passed with a legally valid will, they're considered testate. If they died without leaving a will or without leaving a will that's compliant with Texas laws, they're known as intestate. Testator is a name for the person who is signing or has signed the will. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is your stuff. It's the property that is both real property, that'd be real estate, and any personal property that is owned by the decedent at the time that they passed. Probate is the court process of winding up a person's affairs. There's only, I think it's only 7 counties. There's not that many counties in Texas that have probate courts. If you're in a county, Harris County has 5 probate courts. Fort Bend County does not have probate courts. They're handled in the county court at law. Our other neighboring county that has a probate court is Galveston. Whether you had a will or not, it's called the probate process. But administration is the legal term when someone passes without a will. I use the term personal representative as a catch-all, but it's also known as an executor or an administrator, and that's the person who's responsible for wrapping up your affairs and distributing your assets to the beneficiaries. And an heir or beneficiary is a person who inherits either through a will or by law. There's a lot of common mistakes in estate planning. I ran into some just the other day at work. Powers of attorney are only valid while someone is living. Once someone has passed away, the power of attorney is void. It is worthless once that person has died. A lot of people think because Texas is a community property state that they don't need to worry about their house because, whichever spouse dies first, the other spouse will get the house, right? That is not necessarily true. A surviving spouse does have the right to remain in the home for the rest of their life, even if it's separate property and not community property. They can remain in the home, but they do have to be responsible for any loans, property taxes, and maintenance. The big sticky issue with the life estate is if you have a home that's community property, it's a little easier. But if you move into a home that one spouse purchased before you were married and it has remained their separate property, if they have any children from a prior relationship, those children have a right to half the house. Another thing that I've been running into a lot, and I'm glad that Miss Nia brought that up at the beginning, if someone has a will, you have to go through the probate process. Property doesn't automatically transfer just because a person was named in the will. That is also true if it's a home that's been in the family for generations. It is not automatically transferred to the next generation. The family still has to go through a legal process to have clear title to that home. When you choose an executor, or when the family determines who's going to be the administrator for an estate, they have to be over the age of 18, and they need to be Texas residents. They can live outside the state if they have a registered agent here in Texas, but it's much easier to have someone who lives in Texas as your executor. Another issue that comes up all the time is that children under the age of 18 cannot legally inherit. They cannot inherit until they turn 18. We have forms on our website, Texas Law Help, that will walk you through the process of the will. That's great, but it's really best to have an attorney prepare your will. And here in Harris County, if you receive the AMOS emails, we can connect you with a lot of great will clinics where you will get your estate plans without charge. You do not want to use forms that you've downloaded from the internet. Like LegalZoom, they may not be valid. I have seen families spend all of their money on attorneys and court fees because the parent didn't want to spend money having an attorney prepare the will, and they just got a form off the internet, and it doesn't work. It doesn't comply with Texas law. There are forms that are approved by the Texas Supreme Court for doing the will yourself. You can find them on our website. And another thing that people don't realize is that spouses must have separate wills. You can't prepare one will that works for both of you. Texas law does allow you to handwrite your wills. This was terrific during COVID. That's called a holographic will. And if you want more information on how to do that, please go to Texas Law Help. Please keep your will in a safe place that your loved ones know about. Excuse me. We can tell you lots of stories of people that kept the will in a safe deposit box and neglected to tell their family anything about where the safe deposit was, putting them on permission to have access to the safe deposit, and that makes it a lot harder for them to access the will. It is very important for your executor to be able to find your original will. If they cannot find it, Texas law presumes that you have torn up the will and revoked it. It's really important to realize if you die without a legally valid will, the law determines who will inherit your property. There's a very complicated chart that explains that. And basically, it's not automatic. It's not as clear cut as you would think. If you cannot find a will, you need to file an application for administration. You either file for dependent or independent administration. I'll go into detail on that in a moment. In extremely limited cases, you can file a small estate affidavit. Texas requires that you have an attorney for probate. One of the important reasons for that is there are several different processes, and the attorney will know the best way to proceed. A lot of people get really angry at me when I tell them you have to have an attorney for probate. The reason why you can't do this on your own is you're not just representing yourself in probate. If you're the personal representative, you're representing the interests of all of the heirs, any creditors, that would be people that the deceased person owed money to, and you're representing the interests of the estate itself. The estate becomes a separate legal entity. There are only two very narrow exceptions where you would not need an attorney. If you qualify for a small estate affidavit, you don't need an attorney. You can do that on your own. And this is a relatively new Texas court decision, but some courts may let you probate a will as a muniment of title if you are the only heir in the will. A muniment of title is something I'll go into detail, but basically that's a probate process where the only thing you need to do is transfer property to the heir. And if you are the heir and the executor, Some courts might let you do that on your own. Texas has what we call probate and non-probate assets. Probate assets are property in the testator's name, so that's the person who signed the will, such as real property and personal property. So those are things that you would name in your will and state that, you know, who you would want them to go to. Those go through the probate process. Texas has a wonderful thing called non-probate assets. Non-probate assets don't have to be transferred through the probate court if there are properly named beneficiaries. They pass in accordance with the terms of a contract. Common examples include the following: life insurance policies, retirement plans, and payable and death accounts. If you learn nothing else today, I really hope that you learn this. If you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your home or any other real property that you own, there's a good chance that your family will not need to probate your will. You should always have a will because there's a chance that you forget to transfer something properly, but there is a very good way that you can avoid the probate process. I'm going to repeat this a couple of times because every time I give this presentation, people ask me, you know, why can't I just have a trust? I don't want my family to have to go through probate. Trusts aren't necessary for most of us, but you can still accomplish the same goals by having these beneficiaries. So I'm going to go briefly over the types of proceedings in probate court. Probate of a will or independent administration are fairly similar. You can have, if someone passes without a will and all of the legal heirs are over the age of 18 and they all agree, and that's the critical part, they have to all agree, you can have what is called independent administration, and that works just about as smoothly as probating a will. The attorney starts the probate process by filing an application. After they file that application and deliver the original will to the courthouse, once that has been on record for 10 days, the attorney can schedule the hearing. That does not mean that you will have a hearing 10 days after your attorney files the application. Harris County, I'm not sure what the latest dates are, but a few years ago, it was not unusual for it to go 6 months or more. The courts are so backed up here that it really does take a long time for you to get in front of the judge. The hearing sounds really intimidating, but it's not. In this case, I've had a lot of clients that are afraid because just the idea of going in front of a judge sounds challenging. In this case, it's a very simple 5 to 10 minute process where the attorney explains the situation to the judge, and then your attorney will ask you questions to say that, yes, this is my loved one's will. I recognize their handwriting. I know they didn't have any wills after that. It's really straightforward and easy. Once the judge grants the application for probate of the will, the personal representative receives letters testamentary if there was a will, and the personal representative receives letters of administration if there was no will. The personal representative then gathers all of the assets of the estate, and they have to open a bank account for the estate. So they also have to get like I said earlier, an estate is a separate legal entity, and you have to get a tax ID for it. Your attorney notifies all the creditors. You, as the personal representative, are absolutely not responsible for any debt of the estate. The debt gets paid out of the estate's assets, not your personal assets. And also in Texas, there is a very strict process of filing a claim against the estate. If the creditors don't use very specific language in their application to the court, it's not considered a valid claim. And then the final thing that you do with a probate of will or independent administration is that the attorney and the personal representative prepare and file an inventory. That is a record of everything the person owned as of the date of death, as well as any claims, any amount due to the person who passed away. I always say, please have a will. This is the absolute easiest way to make sure that everything goes smoothly. It's quite easy. People think that probate sounds like an awful word and it costs a lot of money. In Texas, probate is not that expensive. I know in other states that it can be, but here, if there aren't any fights, if no one challenges what is called a will contest, the fees are not that bad. Like I said earlier, the hearing in front of the judge is called a prove-up hearing, and that's usually less than 5 minutes. And then the judge admits the will to probate and orders the issuance of letters testamentary. And
Miss-
letters testamentary,
Miss Lisa, can you back up just a minute when you talk about the expense of probate? Can you clarify about it's not the probate that's expensive, it's the attorney's fees and costs that are more expensive? Because when
Thank
you say
you.
it's not that expensive, it's a little
Yeah,
misleading.
that's a great point. And I've been out
Okay.
of private practice for a while, so thank you. I will always say, if you can have a transfer on death deed and payable on death beneficiaries, that is the best, least expensive way to go. Probate court costs are not that expensive. They will be under $1,000. Attorney's fees can be a lot more than that. And I don't know what the going rate is at this point, but I wouldn't be surprised if it's $5,000. That being said, a trust is going to cost you at least $10,000. So that's another way to look at it. I know that in California, the cost for probate, I believe, is a percentage of the value of the estate, and that's why it gets a lot more expensive. But yes, I'm glad that Miss Nia reminded me. It is not cheap, but it's not as expensive as having a trust. Okay, intestate estates are where it gets messy and can get extremely expensive. If all of the heirs are over the age of 18 and agree to appoint the same person for personal representative, you can have an independent administration. That is also a pretty simple hearing. It's usually less than 15 minutes. You will get, once the judge, I read through this 20 times. The judge does not admit the will to probate. The judge appoints the administrator and orders the issuance of letters of administration. And letters of administration are the same thing as letters testamentary. It's the official document that gives the personal representative the right to manage the estate. Again, the attorney notifies the beneficiaries and creditors, and the attorney and executor prepare and file an inventory. You can also file what's known as an affidavit in lieu of inventory. If you file an inventory, it has a detailed list of everything the person owned on the day they passed away. A lot of people very wisely want to keep that information private. Anything you file in court is a public record. Anyone can go and look it up. So you can now file what's known as an affidavit in lieu of inventory. And that's just a statement that I have notified all of the beneficiaries of the estate assets and debts. This is where it gets really messy and expensive. A dependent administration requires strict court supervision. If people don't agree, or there is someone under the age of 18 who is an heir, you have to file an application for dependent administration. And everybody thinks their family is going to get along great when they pass. That almost never happens. I'm really sorry to say that, but everyone I've talked to said, I don't need to worry about a will. All my children get along so well. You do not know how people grieve. And a lot of times, a lot of old family arguments will come back up. I mean, I have personally known people that have said, I don't care if all the money goes to lawyers. I don't want my sister to get anything. That happens a lot. So a dependent administration has to be supervised very strictly by the court, and it takes a very long time. The dependent administrator has to post a bond, which is a percentage of the value of the estate. That's to show that they're not going to run off with all of the estate property. Everything you do has to be approved by the court. And I mean everything. You have to go to court every month to keep the lights on, to get the grass cut. Anything spent by money of the estate has to be approved by a judge. There is one good reason to have a dependent administration. If someone had a lot of property, but they also had a very significant amount of debt, it can protect them because it's a lot more difficult for creditors to get paid when there's a dependent administration. When there is no will, there is an additional process you have to go through. It's called an application for determination of heirship, and that's for both independent and dependent administration. So what happens when someone files an application for administration? They also file the application for determination of heirship. This is required by law to make sure that every single heir is aware of this process. Every single person is aware that there is an estate. So the attorney appoints a neutral party. It's an attorney ad litem whose job is to investigate the family history. They do a lot of research. They talk to family members. You have to name 2 disinterested witnesses. That means people who knew the deceased person very well, but cannot legally inherit. And that way, those people can speak as to who the entire family is. There's a hearing with the ad litem, the attorney for the estate, and the witnesses, and the person who is going to manage the estate. That usually is less than half an hour. And once the judge is satisfied that all of the heirs have been named and notified, the judge signs an order that lists every single heir and what their share and interest is in the estate. Now, there's a simple process if someone had a legally valid will, and the only thing you need to do is transfer property. You can also use it in some cases to transfer bank accounts or other financial accounts. This process may be used more than 4 years after date of death. For probating a will and for administration, it needs to happen within 4 years of the date of death. If you only need to transfer property, you may use this process. If it's been more than 4 years, you do have to prove to the judge that there is a good reason why you did not probate within 4 years. The best example I ever saw was a woman who had no idea that her husband had a will, and many years had passed, and she decided to sell the house. While she was cleaning out the house, she found a safe, and that safe was a will. When she explained that to the judge said, okay, I will still let you probate this will. So you do have to prove you didn't delay on purpose. Muniment is a complicated word, but it's a legal document for a document, title, deed, or other evidence that indicates ownership of property. There has to be a legally valid will. Here comes the one tricky part. Everybody who can legally inherit has to agree to probate the will. I had a situation where this gentleman had bought a house with his mother-in-law, and she left she left the house to him in her will. He didn't know he needed to probate the will. About 30 years later, he found out that he still didn't have clear title to the house. And so he came to the office where I worked at the time for help with probate. We had to track down about 40 people because she had a large family. A lot of those original children had also passed in the last 30 years. So we had to track down grandchildren. I think the case is still going on, to be honest. So, you don't want to do this unless you have a pretty straightforward reason, but it is something you can do that's fairly simple. The only thing you have to do, you go to court, you explain to the judge that the only thing you need to do is transfer property. All of the other estate issues have been resolved. All of the heirs agree that you can use this process. The judge will admit the will to probate as muniment of title, which means the will is a valid legal document that demonstrates that the person named in the will has title to the house. And so you would record a copy of the signed order and the will and the property records. Like I said, there is new case law in Texas that came out last year that allowed someone to file pro se, or in other words, represent herself, because she was the only beneficiary, both the only living beneficiary and the only one named in the will. there is a big problem, and I know it's a problem in Harris County. I'm not sure about other counties, where people will go to the probate clerk's office and say, my relative passed away, they didn't have a will, I don't have a lawyer, what do I do? And the clerk, who is not a lawyer, will say, oh, you can do a small estate affidavit. That is absolutely not true. Small estate affidavits can only be used to transfer property if the following conditions are met. It can only be used to transfer a home if there is a surviving spouse or a child under the age of 18. If you are an adult child who was your parent's caregiver that lived in the home, you cannot use the small estate affidavit to transfer your house. And you will not get your money back. You'll be out $400 and you'll still have to go through another legal process. With the small estate affidavit, the person lists everything that the deceased person owned. It has to be signed by all of the heirs, so that could be a spouse and children, or nieces and nephews, whoever the next of kin are. And you also have to have it signed by those two disinterested witnesses who say, yes, we have reviewed this, it is true, they have named all the heirs. This cannot be used if the deceased person had a will. They had to have not had a will. And it cannot be used if the assets are if the assets are lower than the debts. So if someone had, say, $20,000 in assets, but $40,000 in credit card debt and other debts, they would not be able to use the small estate affidavit. Also, the estate, excluding the homestead, must be less than $75,000. The homestead does not count in the assets. The homestead is considered exempt. As I said earlier, every time it's not just every time I give this presentation, it's pretty much every time I'm out in the community talking about probate, people want to trust. Trusts have the greatest PR in the world. I wish I could get that kind of PR, because everybody wants a trust. A trust is a legal document that states how the testator's property is to be distributed at death. It can transfer both your real property and your personal property. A big problem with trusts is people don't realize that you have to transfer the property to the trust, and it is not simple. A reason why it is so expensive for an attorney to prepare a trust is because they should have a person in their office who will get a spreadsheet of all of your property, and that person will make sure that everything is transferred correctly. So if you get a form on the internet and create your own trust, you may not transfer the property correctly. You know, there are people that go to an attorney where the attorney does not help them with transferring the property. They just own a very expensive 100 pages of paper. There is no trust without property transferred to it. There are a few good reasons to have trusts. It is a great way to protect assets, so someone can qualify for Medicaid, for nursing homes. Trusts are great if you need to have control after your death. They can be great for blended families, where you want to make sure that your kids get your assets, not your spouse's new wife. And again, it does avoid probate court. But you can accomplish the same goal if you correctly name beneficiaries to all of your financial accounts and use a transfer on death deed for any real property that you own. So a lot of people have no idea that they don't have clear title to their home. They think, this is my family home. My grandmother left this home to me. But it doesn't automatically transfer to you. So if you don't have clear title, you don't qualify for any type of disaster assistance. You know, you will go to FEMA, you will go to state programs and apply, and they can't help you because you don't have clear title. So you'll have to halt, get your title clear, and then go back and put in an application. You also aren't eligible for property tax exemptions or deferrals if you're not the owner. A clear title means that nobody else has a financial interest in your property. It means that there's no question of ownership, and that ownership history is, and when I say ownership history is clear, that someone could go to the county deed records and they would be very clear that house went to A, to B, to C, to you. When property is not legally transferred to the subsequent owner, it's called a cloudy title. This happens very often when someone dies without a will or when the family doesn't manage the estate. Title is the legal right to your property. That's what I just explained in the previous slide. Title is the legal right. The deed conveys, the deed is the piece of paper that conveys the right to title. So real estate title is not a document. It is the strength of your claim. And having a clear title means there are no unexpected claims on the property. A deed is, like I said, that document that transfers ownership to the new owner. Clear title is critical, along with disaster assistance and property tax relief. With clear title, you can get home improvement and other types of loans. I had an argument with someone who contacted our office for help yesterday because she kept insisting that she didn't need to probate her husband's will to have title to her house. If you don't go through the probate process, you might not have clear title and you might not be able to access any bank accounts if you don't probate the estate. It's unfortunate that so many people think that just having that will is enough to give them ownership rights. It is not. So there's a few ways to clear title through the courts. If the homeowner died within 4 years, you can go through the probate process, whether it's probating a will or application for administration. If you're a surviving spouse and there is no will, you can file a small estate affidavit. If it's been more than 4 years, you can use that process known as probating as a muniment of title if there was a will. And another way to clear title, if you meet the requirements, is a petition for adverse possession. So traditional probate is a fairly simple way to probate a will. It's a clear title, either going through the traditional probate process or filing an application for administration. And the muniment of title, as I said earlier, may work if you have a very good reason for not probating the will within 4 years, all beneficiaries agree, and there's a legally valid will. A small estate affidavit works for surviving spouse or minor child. There cannot be a will if there's all the heirs have to agree. So even if there's a surviving spouse, that spouse has to go to all the person's heirs and get them to agree to the small estate affidavit. And again, it's signed by all the heirs and 2 witnesses. There is no court process when you do the small estate affidavit. You file it with the clerk, and then the judge signs an order if all of the elements of the law have been met. Most people have heard of adverse possession. It's a legal principle that allows you to obtain legal ownership of a property if you have continuously lived there for a specified length of time. There are a few different statutes that have different lengths of time. Usually it's around 15 years that you have to have lived on that property. One thing that is critical is you have to make sure that the whole world knows that that's where you live. You get your mail there. You keep the grass cut there. Everybody knows this is your house. Everyone knows you live there. If it's a vacant lot, there's a lot that's abandoned next to their house. So they clean it up, they put a garden on, they let kids play on it, but everybody knows, oh, that's Miss Nia's property. She takes care of it. You cannot do this if you have permission to reside at that property. I ran into situations where everyone in the family agreed that one person could live at that house. They did not agree that that person could have title. The title would transfer to all of them, and that one person could live there. In that case, you cannot have adverse possession because you had permission. Another way that's a very common way to clear title is an affidavit of heirship. This is a process that you do not need an attorney for. It's a legal document that is used to give property to the heirs of a deceased person. It can be needed if the homeowner did not have a will or the will was not probated within 4 years. We have a form on our website at texaslawhelp.org. Again, this only has to be signed by 2 witnesses. It has to be signed by two people who cannot legally inherit, but who knew the deceased person and their family history very well. It is critical that you have the full legal description. It's found on the deed. You cannot use the legal description on the property tax bill. If you can't find a deed, you can call your county clerk's office in the county where the property is located, or there's a website called texasfile.com where it's fairly simple to look up your deed. You can look up your deeds on the county clerk's office. The Harris County clerk's property records are not easy to use. I've done it for many years, and it still takes me a lot of time to look up the deeds. The affidavit of heirship has to be filed in the county where the property is located. There's a small filing fee. This filing fee is much less than probate. The filing fee is probably going to be less than $50. Harris County charges a little more per page, and it just depends on how many pages the affidavit of heirship is. It gets confusing because I use the term affidavit a few times. Now, a small estate affidavit is approved by the judge, and that can only be used to transfer real property to a surviving spouse or minor children. Another situation, if the person didn't own property, but they had bank accounts without beneficiaries, you can use a small estate affidavit for that. Affidavit of heirship, you can transfer a home to a surviving spouse, adult children, or any other legal heirs. So small estate affidavit, spouse or minor child, affidavit of heirship, any heir. And if the house is the only estate asset, you can use an affidavit of heirship. When I used to work at the Earl Carl Institute, where the majority of what I did was clearing title, I would tell my clients, please make sure that this doesn't happen to your children. Let's prevent this for the rest of your family. Transfer on death deed is a wonderful law. It's a simple, inexpensive way for you to transfer a home or any other real estate that you own to someone upon your death. If you use a transfer on death deed, you still own the house 100%. You can still sell the property, use it as collateral for loans, get your property tax exemptions. Your beneficiary has absolutely no right until after the owner passes away. The owner can also change the beneficiary or cancel the deed entirely. I don't want to use this transfer on death deed anymore. I changed my mind and I don't want this child to inherit it. I want my grandchild to inherit it. You can absolutely change it. The most critical thing, two critical things. You have to have the legal description, and the deed has to be filed before you pass away. If you have a transfer on death deed and you put it in a safe spot with your will, it's worthless. It only is valid if you have transferred it before you pass. A lot of people will ask me about ladybird deeds. It's also called an enhanced life estate deed. The TOD, the transfer on death deed, is covered by Texas law. It's covered by a statute. The ladybird deed is not covered by any written law. It's covered by what is known as common law, which is kind of the legal tradition. The couple advantages of a ladybird deed: if you are a caregiver for someone who is incapacitated, say they have dementia, you as their agent under a power of attorney can sign a ladybird deed to protect their home. And ladybird deeds are accepted in 5 states, including Texas. TOD are accepted in significantly more. The discussion for this presentation is solely for Texas law. I am not licensed in any other states, and I'm not aware of the laws in other states. A great thing about both the ladybird deed and the TOD, they avoid probate and Medicaid estate recovery. If you use Medicaid to pay for your nursing home, which is a very common thing, DHHS can intervene in a probate case to seek reimbursement for the expenses that they paid. They want to recoup their losses. So if you transfer a house through a TOD or a ladybird deed, Medicaid will not try to seek reimbursement. So that's another great reason to use it. And I just want to reiterate with the TOD, I can't tell you enough how great the TOD is. It's going to cost you $40 or $50 to record in the deed office. So that's 40 or 50 worth, as opposed to 5,000 plus for probate. You'll get a copy of this chart. It's just an example of the differences between the Todd and Ladybird deed. I would recommend using the Todd, the transfer on death deed, unless the homeowner does not have the capacity to sign a deed. Then you could use a Ladybird deed. We have a toolkit on our website that walks you through the step of the transfer on death deed. Get on the AMOS email list because we just had a fabulous Todd clinic, and I'm sure there will be more. I cannot state enough how critical it is to have the full legal description. I have done workshops where I will have 4 or 5 slides explaining how to get your legal description from your deed, and 20 people will come up to me after I talk and show me that they filled the Todd out with the description on the property tax bill. If you only use your property tax description on your transfer on death deed, your affidavit of heirship, your Ladybird deed, it is not a valid deed, and it will cause your whoever inherits the home to have a cloudy title. And again, it protects your family from Medicaid estate recovery. We have a lot of great resources in Harris County. I have our website at the top. It will give you, I don't even know, thousands of articles on any civil law issue. We also have attorneys available for online chat 10 to 2 Monday through Thursday. We have another great program for Texans over 60 or people on Medicaid, on Medicare, called the Hotline for Texans, that can help with estate planning and Medicare issues. Earl Carl Property Preservation at Texas Southern has a fabulous program, and their mission is to help families protect and build their generational wealth. Lone Star Legal Aid and Houston Volunteer Lawyers provide free legal aid to people in the area. Don't ever count yourself out. Some programs have very strict income limitations. I know for a fact that Lone Star Legal Aid and Houston Volunteer Lawyers have a lot more flexibility in who they can accept. Legal Line is a program through the Houston Bar Association where I believe it's all online now, but you can apply to get free advice from an attorney. The attorney can't take your case, but they can give you advice, and it has no income limits. And then Houston Lawyer Referral Service is a great resource if you're looking for an attorney to help you. And they do have people that will charge lower rates. Thank you very much for your time. I will stick around and can answer any questions you have after my partners give their presentation.
All right. Thank you so much, Ms. Lisa. And as an FYI, all of the resources, copies of the documents, everything that she sent, all the links, I'll send out. I'll be emailing them out to everybody. So you'll have them. So don't, if you miss something in the notes or whatever, this session is being recorded. The recording is also going to be sent out so that you guys can go back and look at it as well. So calm down if you. All right. Just want to make sure. All right. Miss Mabel, we're going to have Miss Mabel Menifee with the Harris Central Appraisal District next.
Yes, I am putting my presentation up right now.
We see your Zoom AI companion screen.
Okay, let me. Share again. Let me just share.
Texas Legal Services Center, the resource information, all of that will all be on the email. All that'll be already there. Miss Lisa, but somebody's asking real quick, can you give your the phone number where you can be reached?
Yes, I can put that in the chat. And you can always find me by reaching out to Miss Nia. She knows how to find me wherever I am.
All right, everyone. I am working on this. It was working perfectly a minute ago. And
that's all right. Go right ahead.
If we will screen share too.
She's typing it in the chat here.
Is that showing up now? No?
Yes, ma'am.
It is? Okay,
Yes, ma'am.
and let me,
But put it in
Gotcha.
presentation mode.
right,
It's Lisa Nelson.
all right,
Lisa
here we go,
Nelson.
and let me do screen.
And it's
You're
Nelson
good.
with S-E-N,
Nope,
not
nope,
S-O-N.
you had it right the first time, Miss Mabel. Switch it back. Swap presentation view.
Okay, all
Yep,
right.
you're good.
Okay. All right, everyone. Good afternoon again. My name is Mabel Menifee. I'm with the Harris Central Appraisal District, and I'm here to sort of hopefully fill in of some of the blanks as it relates to what the presentation that Lisa just gave concerning property taxes and exemptions and the like, particularly when you're talking about inherited property, because they do play a role in, and there are some things that you definitely need to be aware of as you are going through that process. So let's just kind of we'll go ahead and get started with that, and I'll talk about just for those of you maybe new to Texas or it's the first time that you've actually become a property owner, a little bit about what HCAD does, what appraisal districts do. Um, we are the folks that provide the property values for all of the taxing jurisdictions that you pay to. Most homeowners are going to pay to usually around 4 or 5 taxing jurisdictions. That's going to include their city taxes, their county taxes, school taxes, maybe community college or hospital. And in some cases, depending on where you live, you may be paying to other special districts such as MUDs. And the reason it is set up the way that it is in Texas, and property taxes play such an important role, rather outsized role, as some people would say, is that Texas does not have a state income tax like many states do. So all of the local expenditures for cities and counties, the roads, the fire department, schools, again, things I've mentioned, police and fire protection, are all paid for through property taxes. And in Harris County, there are over 600 property tax entities. And as I mentioned before, depending on where you live, you may only pay to a couple of them. A lot of people think that the property tax system is driven by the county. The laws themselves, the Texas Property Tax Code, is designed and originates with the Texas State Legislature. So as well as things that are in the Texas Constitution, but the state board that does have oversight over appraisal districts, which there's one, as I may have mentioned, in each county, is the Texas Comptroller's Office. So again, as I mentioned, the role of appraisal districts, so the main things that we do is that we value property, we appraise all property, whether that's county property, in all property in the county, and that's going to be homes, that'll be commercial property, agricultural property, industrial, and something called business personal. And the role of the appraisal district is to do so each year as of January the 1st, and they're required to do so and provide what that property is, what the market value of that property is. The other thing that we do at HCAD is that we administer exemptions, and that's the real important piece we want to get into today. We also certify those appraisal rolls so that taxing jurisdictions can set their rates. A lot of people think that HCAD is responsible for lowering or raising their taxes. We simply do the values and we administer the exemptions. The tax rates are set by your jurisdictions. And a little bit later, my colleague from the tax office is going to come on and talk to you a little bit about that piece as far as your tax rates, tax bills, and the payment processes for those. So be sure to stay with us so we'll take you through the entire process, both sides of the property tax coin, as I like to say. Appraisal districts also try to keep that system fair because there's only one entity in the county that is valuing the property, and that is us. And that gives everyone the opportunity, if they disagree with that property value, they have one place to go, that's the appraisal district, in order to appeal that value. And that's something that we're getting into a season of, and I will quickly mention here that for those of you who have value notices, have been receiving your value notices, which they started being mailed a few days ago. Many of them have hit the mailbox. Some, if you haven't received yours and you're interested in finding out what your 2026 value is, you can go to our website at hcad.org. But again, that process is beginning, and as Nia mentioned, we have an entire separate series of workshops that we will be doing between now and May 15th, the protest deadline, to help you understand that process, as well as give you some ideas and ways to protest that value or appeal that value if you disagree with it. So the appraisal district, our CEO or our chief appraiser is head of the organization, and we also have a 9-member administrative board. 3 of those board members are publicly elected by you, and the remaining 6 are elected by the jurisdictions that we serve. I mentioned quickly the annual value notice, but what I wanted to really call attention to here is the difference between the appraised value and the market value, because that's going to help set the stage for what we're going to be talking about as far as exemptions are concerned. The appraised value, when you get your value notice, there will be two values on that notice. One is the appraised, the other is the market value. The market value is what HCAD determines, and that's going to be the value at which we've determined that property would sell for to a willing buyer on the open market. And that's generally determined by the sales that have already taken place over the last 12 months or so in your area. The appraised value, now that's the value that your taxes are going to be based on. And that appraised value is also what is used by the tax office in calculating your tax bill. It could be the same as the market value, but it's also maybe lower because of the exemptions that you have in place that offer several opportunities to save money on your taxes, and that includes that a 10% appraisal increase cap, as well as certain savings or discounts that you get as a result of being eligible for a homestead exemption. And and keep in mind, these are things that you will want to make sure you consider in terms of when you're taking over a property from a relative or whatever. It's also important that I just want to mention, I did mention that the date of appraisal is January the 1st. So whenever a property is appraised, it's appraised based on its condition as of January the 1st of that year. If something happens after January the 1st, that's not necessarily going to be taken into consideration in terms of your value until the following January the 1st, in which case that goes on. So it's important to know that sometimes failure to meet these deadlines when you can cost you additional money because you've kind of lost out on the right to make any changes, particularly when it comes to protesting, or sometimes when it comes to actually applying for your exemptions, or making sure if you've assumed the property of a deceased relative, you're an heir to a property and you move into that property, making sure that those exemptions that previous owner may have been eligible for, that you are not eligible for, are therefore removed from the property's records, so that your tax bill is going to be correct. You're not paying less than you should be, and you're not paying more than you should be paying. So once again, the protest deadline, May 15th, or 30 days from the date of that notice, whichever comes later. And then also the tax bills are usually mailed in October, and then on February the 1st, they are delinquent. The reason these dates are so important, again, is because of the annual funding that jurisdictions are provided, and these are the deadlines to make that happen. So there can be penalties and issues when those deadlines aren't met by the property owner. So let's talk a bit now. Let's talk about exemptions, and these are the exemptions that people get as a homeowner on their primary residence And they basically are, depending on their qualifications, they save money as far as your tax rates are concerned. And HCAT administers these, so you would apply for those through us. And again, these are used by the taxing authority in calculating your property tax bill. So basically, they exclude a part of your property from being taxed, from taxation. And the most common ones that people are going to have are the general resident homestead, the over 65, which is in addition to the general resident homestead exemption, the over 55 surviving spouse exemption, their disability exemption, and there are a number of different disabled veterans exemptions that a homeowner could have, as well as some other service-related exemptions, such as those related to a first responder killed in the line of duty. So a little bit about the most common one is the general resident homestead exemption. And anyone who lives in a property, owns it, their name is on the deed, and they don't, and that's their primary residence, they can receive this exemption. We do require a little bit of documentation, of course, proof of ownership, as well as a driver's license that matches that of the property's address. So you get this 10% appraisal increase cap when you have that one. And that cap, what that basically means is that as a result of having your homestead exemption, in the event your property value rises more than 10% in 1 year, and we've seen that happen a lot in recent years, you will never your taxes will never go higher than that 10% that any increase is capped at 10%. You also get, and here's a big one, you get $140,000 school tax exemption, and that's by state law. Every school district in the state has to offer that. That basically means if you have a $340,000 house, for instance, well, your tax is only going to be based on a $200,000 house. There are other exemptions that you might be able to get that may be on a property owner's record account based on where they live. Different jurisdictions offer different kinds of exemptions. City of Houston offers one, so does the county. In some cases, of course, the school districts are required by the state to do so. The others are typically voted on by the local governing bodies. The over 65 and the disability exemption, these are both basically the same. And as I mentioned, they are on top of the general resident homestead exemption. So once you turn 65 years of age, or once you are classified as disabled, either through Social Security, under the Federal Old Age and Survivors and Disability Insurance Act, or in the case of someone who is totally disabled and may not be on Social Security, you can provide HCAT with a physician statement in order to obtain that position, in order to obtain that exemption, rather. The benefits of that exemption is that you get an additional $60,000 off of your school taxes. And that means, in other words, you go from 140,000 of a discount to 200,000. So a $300,000 home, as we mentioned earlier, you're only paying taxes on 100,000 of that value. Excuse me. You also, of course, get all the general resident homestead exemptions as part of that. And you're also eligible for something called a tax deferral, and you can pay your taxes in installments without penalties when you have that over 65 exemption. Other exemptions can be granted by individual jurisdictions, and the tax office, which they're going to talk about in a few minutes, also offers some special payment options for folks with that over 65 and disability exemption. Now, couple of things I want to mention in terms of these benefits for over 65 homeowners that a person a previous owner may have had. I mentioned that you're eligible for a tax deferral and you can pay taxes in installments. So we're going to talk a little bit about that tax deferral, because in some cases that is what some property owners may encounter when they are heirs to the property of an older relative who is now deceased. But before that, I also wanted to mention that over 55 surviving spouse exemption that a person may have, and that is if the spouse, owner, co-owner, the spouse who passed away died in a year in which they were over 65 or receiving the disability exemption, as long as the surviving spouse is 55 years of age or older on the date of their spouse's death, they continue to receive all of those over 65 exemption benefits. And that's real important because there's no interruption in terms of being able to continue to pay and maintain that cap that they've had, probably for a number of years. The important thing to remember here is that we are in the process of probably about 25 years ago or so, there was the records process did not have a space for people to put their age on. For most of the time, when we have your records of a couple who may be receiving the over 65 exemption, we'll have the age of both spouses on their record now. We can grant this automatically. But if it's an older account, you may want to contact HCAT to make sure that the spouse continues that exemption. So I just want to make sure you mention that. Typically, we now can automatically apply that exemption. But again, if you lived in the house, if the house has been lived in by that couple for more than 25 years, it's always a good idea to contact us to make sure that spouse continues to receive that exemption. There are also a number of veterans exemptions that I've listed here that someone may have. There's a total VA if they were totally disabled. There's also one for the surviving spouse. If she was the wife or vice versa of the survivor or husband of the veteran. There's also one for the disabled. There's also a disabled veterans exemption, additional ones, and others that you can see here. So if that person was a veteran and maybe affected by a disability, that is another clue that you want to make sure you check those exemptions if you're inheriting that property. The immediate resident homestead exemption, I'm not sure if this is going to necessarily apply to you all, but if you're planning on moving into a new home, you can also get an exemption that prorates you. Remember, I talked about January the 1st being the usual date of whatever happens with HCAS when we start applying it. Well, not so much with this new immediate resident homestead exemption. You can actually start receiving that exemption as soon as you move into, as soon as you acquire the property. You have 1 year from the date you acquire the property to apply for this exemption. Otherwise, you'll lose out. If the previous owner did not have exemption on their property, the home was never occupied, such as in a new construction, then this is going to be the most common way to receive that exemption. So you want to keep that in mind. Now we're going to get to something called the heirship exemption. And this is really important for people who are inheriting property from an heir, because over and over again, we see where people forget who think that, I guess the best way of putting it is that the exemptions on the home, or they may look at it and say, oh, my grandmother was receiving you know, her taxes are very cheap on this house. This is something that's very attractive to as a place that I might want to live. You have to keep in mind that, again, as I've been explaining, the exemptions go with the person and whether and their eligibility. They do not go with the property. So if you're moving into a property, those exemptions may not belong to you. And if you stay there too long without making sure you've applied for the exemptions that you're eligible for, you will of course have to pay, you will of course be billed for repaying the amount of taxes that you did not pay because you were not eligible for those exemptions. So that's an important thing to keep in mind if you are inheriting property. And if you will excuse me, I have one of those lights that goes off automatically when no one moves for a long time. So let's go back to the heirship exemption. Heirship property, as Lisa has been talking about, refers to land or homes passed down through generations without a clear or updated title. And of course, that happens when someone in the family dies and doesn't leave a will, and there could be multiple heirs that are now there to share the property. In some cases, people have been living in homes for years where other relatives own an interest in the property, and they may have been unable to claim it as their homestead or receive that over 65 exemption for the property because they were not they did not own it at 100%. You may be able to get some relief from that under the heirship exemption rule. So on our application, on our HCAT exemptions application for resident homestead exemption, under section 3 of that application, which can be found on our website, you have the opportunity to check whether or not that's an heir property. And if you answer yes, and if you answer do other owners occupy the property, you're going to be directed to follow several steps that allow you to submit the appropriate paperwork in order to obtain the 100% exemption, because say you have 3 other heirs, under normal circumstances, you only own 25% you only have a 25% interest in the property, in which case you would only be eligible for 25% of a exemption. In this case, because you're living in the house and the other heirs recognize that you know, you're paying for it, you're taking care of the property, and you are living there. And in some cases, they may have their own homestead exemption someplace else. You can get that exemption savings at 100%. And it's also important for the other heirs to understand that by granting you the exemption on the property, the homestead exemption on the property, in no way affects their ownership rights to the property. It simply gives you the same right to that exemption as they might have in their home somewhere else, or perhaps they're living there in the home with you, and it saves everyone's money expense. So exemptions, how do you apply for them? That's a good question. A lot of people tend to ask, well, how do I know I'm eligible or not eligible for exemption? So we recently came up with something that's now on our website called the Exemption Wizard. And what that does is it asks you a series of questions, and it will tell you whether or not you're eligible for an exemption and which exemptions you would be eligible for. And then once you understand or recognize which exemptions you're eligible for, you can go ahead and then apply either through the forms on our website, or you can mail in a paper form. And in some cases, some exemptions are very easy to apply for on our mobile app. You can also email in your exemptions application. We do ask that, depending on when they're submitted, that you make sure you include everything, all of the information that you were asked for, because if you forget to submit something, then that's just going to delay the process a little bit longer. So you want to try to make sure you meet those opportunities so that you can start saving on those exemptions as soon as possible. Once you do apply and it's approved, you're going to be notified. You'll also be notified if you're missing information. There's also, for anyone who's still, a little bit queasy about filling out the application or what they need to have, once you go out on our website, there is also a video that you can actually watch as you fill out your applications. And those applications can be found under our website at www.hcad.org, forms, and under popular forms. Another good example for those of you who may be inheriting property and are not really sure what the exemptions are, you can go out on our website, or you can even go to the tax office's website for that matter, and look at and it shows you what the exemptions are, what they're being applied to. And by that, I mean out on our own HCAD's website, it will show you under the exemptions column. Once you do that, you go into the property search and type in the address or account number or name of the owner. Then it will show you under the exemptions column whether or not there is a resident homestead exemption. It will also show you, but it's because you're looking for it. It's not going to necessarily say that that particular address or that person has an over 65 exemption or a disability exemption, because that's a little bit too much public information to share on a public website. But it will say multiple, and multiple means that there is an additional exemption attached to that property. Now, this is what I'm showing here, is each December, we send out a little postcard to everyone that has exemptions that basically are confirming what those exemptions are. It tells you, and you are required to notify HCAD if your eligibility for those exemptions has ended. So if you received a homestead exemption in error, in which case that could easily happen if you've kind of overlooked checking on those exemptions once you move into either new property or property that you inherited. This card can serve as a reminder to, oops, need to go ahead and reapply for what I'm eligible for, because you don't want to leave those on there for very long, because state law does allow the taxing jurisdictions or the appraisal district to go back 5 years, up to 5 years, in which you could be billed for exemptions, billed for having homestead exemption in error. There could be, depending on the circumstances, some additional penalties if intent to defraud is determined. So just, you want to keep that in mind that's an important thing in terms of your checklist when you inherit property. So if you have any additional questions about that, this is our website. We're located out on the Northwest Freeway, but remember, you don't have to battle 290 to get information from us. You can always call us at 713-957-7800, or you can go to our website at hcad.org, where you will find, as I mentioned before, you can search property information. There are some very instructive videos that you can look at. And if you're planning on protesting, you can get your remote hearing instructions. We also have a schedule of workshops available, and I mentioned those to you earlier for our spring property tax workshops, as well as other activities, renditions, etc. Also, as you can establish your own account with HCAD, and you can also go online and do a contact form where you can describe your your question in a little bit more detail, and that information will be forwarded to the appropriate content expert. So that is hopefully I've kind of provided you with some additional clarification in terms of how property taxes work, and exemptions, mostly exemptions, work in terms of clearing title and inherited property. So I appreciate this opportunity. And now I'm going to turn it over to my colleague in the tax office, where she's going to talk about a little bit more about the property tax, the tax assessor collector, the collections piece, the billing piece of the property tax system. So thank you very much.
Thank you.
All right, thank you, Ms. Mabel. I'll stop your screen share
Yeah,
for you.
you wanna stop?
Hold on. You see the little green button on the top to stop screen share?
Oh, yeah. All right.
Okay, Angela, you're up.
Alrighty. Okay, you guys able to see my screen? Hello?
Yes.
Yeah, we can see it.
All right, perfect. Okay, my name is Angela. I'm from the Harris County Tax Office. Starting the whole thing. Okay. We are the Harris County Tax Office. We are the actual collector. We assess and collect the taxes. What we do here is we register people to vote, we collect property taxes, and we also do vehicle registration. How a tax bill is calculated. So we get the value from HCAD, the appraisal district, and then the jurisdiction itself.
And Angela, I'm sorry,
Yeah.
are you your view, I'm not sure how your Zoom view is on your screen, but we see the box at the bottom for the Zoom.
Oh, what about now?
Yeah, it's good. Got it.
Perfect. Okay.
Yep, you're good.
Okay. So we register people to vote, we collect the property taxes, and then we do auto services like title transfer, auto registration, and such services. But the purpose of this meeting, we're talking about property taxes and how a bill is calculated. So we get the value from the appraisal district around, I would say, August, and basically the taxable value for that jurisdiction or the property itself as a roll file. And each jurisdiction will set a rate for that tax year. So if you have HISD, Harris County, City of Houston, each of those entities set their own tax rate depending on their debt and then their maintenance or whatever they need to be able to maintain the services that they provide for the taxpayer. They set the rate with that information, and they usually set the rate by October. And a bill itself is produced by taking the taxable value times the tax rate, you get the tax bill. So we also have exemptions depending on what kind of exemptions you have, the amount of taxes you paid, can significantly reduce. Typically, most homeowners have a homestead exemption. If you're over the age of 65, you can get approved for an over 65 exemption. If you have some sort of disability, you're able to get a disability exemption. There's also veterans exemption if you are a veteran, depending on your percentage, like from the VA, and you submit that with the appraisal district, and they give us the exemption value, and we reduce the exemption value from the taxable value, and then we tax you on the remaining amount. So if your appraised value is, let's say, $100,000, and you have a homestead of 20%, which is 20% off of that 100,000, that takes away $20,000 off of your value. So the tax office will only tax you on the remaining amount. So meaning we will take $80,000 times the tax rate for that year would be your taxable amount. Okay. Payment plan. So we offer quarterly payment plan for any homeowner that has a homestead plus an over 65 exemption or a disability exemption, even if you're disabled or a veteran, and also surviving spouse. So those are the four main categories that we allow a quarterly payment plan on. So what that means is the tax bill that we bill in January, you can divide that payment into 4 equal installments without assessing penalty and interest. So tax bills are due typically January 31st of whatever year that it's falling upon. So taxes are collected in the rear. So for 2025, it was due January of 2026. But if you are qualifying under a quarterly payment plan, meaning if you're over the age of 65, or if you have a disability, or if you're a disabled veteran, or even if you have a surviving spouse exemption, you are qualified to pay your taxes in 4 equal installment without having to pay any penalty or interest. So for that, the first installment is going to be due January 31st, the second one by March 31st, the third one by May 31st, and then the last one by July 31st. So you basically take your full tax bill, divide it into 4, and that's your amount that you need to pay. Okay. We also offer delinquent payment plans. So this one specifically is only offered after your account becomes delinquent. So we're only able to set this up after January 31st. So come February 1st, we'll be able to set any taxpayer whose account is delinquent into this payment plan. We can offer anywhere between 12 months to 36 months, but if you are on a delinquent payment plan, we do assess penalty and interest on it. That's the only way to be on this payment plan. And to do that, you can go to our website, myharriscountytax.com, or you can give us a call, or you can go to any of our locations and they'll be able to set you up on that payment plan. This is a brand new thing that we just started, which is a prepayment option where if you are wanting to pay your taxes ahead of time, so meaning 2026 taxes, if you want to start paying for it now, we are offering prepayment option where you can set it up a reoccurring payment up until October, up until the next tax bill get released, you're able to make a payment on it. So basically like an escrow on it. And for that, there is no penalty or interest because the account is not delinquent yet. So we do have a new website. We do have the old website plus a new one. This is our payment portal. Our website is still hctax.net, but myharriscountytax.com is a convenient way where people are able to set up a profile where they can set up reminders. You can make a payment. You can save your payment method. You can have receipts. You can set up a payment plan. You can set up a prepayment plan, and you can also this also allows you to do a recurring payment. So it automatically takes that payment out of your account. To do that, you just have to set up a profile on myharriscountytax.com. Okay. To make payments on any sort of payment plans or anything, you can go to our website, hctax.net. When you go to our website, it does, when you click make a payment or schedule a payment online, it does take you to myharriscountytax.net. You can mail in a payment. You can do a check, money order to our PO box, or you can also call us at 713-274-2273 to make a payment over the phone, or you are more than welcome to go to any of our convenient locations. We have 16 locations that you're able to go in and make that payment. You're able to make full or partial payment on your current or prior year taxes. If you are doing a partial payment for like a partial payment, you're not able to do that over the phone, it might be best for you to either go into a location or mail that payment in. You're able to make the payment by credit card. You can do by check, which is free, or e-check online, also free. And all our locations do take cash payments. If you do credit card, there is a processing fee of 2.40%, even if it is debit or credit. I don't have a slide for it, but I am going to go over the deferral payment plans a little bit. So once a person is approved a tax deferral, which again, you do that with the Harris County Appraisal District, once it is set up in the system, a person can keep making payments on those accounts as long as you want to. A deferral allows eligible taxpayer to postpone the payments or of the property taxes of their residents as long as they own or live in that property. So again, it is only set up for people that are eligible for the quarterly payment plan. The deferral is also for the same people. You don't necessarily have to make use of the deferral, but I would say if you are applying for the over 65 exemption or the disabled exemption, it is best to also apply for that deferral just as a protection, because if you do have a deferral, the tax office cannot turn over your account to a collection agency. On a normal account, we turn it over if it is unpaid and if it does not have a payment plan set up in our system by July 1st, we do turn it over to a delinquent collection attorneys where they can start a lawsuit on the account. So the deferral is a protection that is set up for those people where we're not able to turn it over to a collection agency. So the deferral is only for the homesteaded property with all those exemptions that are right there. So over 65, disabled, and surviving spouse as well. You can apply for the deferral at hcat.org. They do have their forms on their website at www.hcat.org. I believe it is Form 3306. It has to be notarized, and you would also need a copy of your driver's license for that deferral. Once you have completed and filed the deferral, HCAT will process and grant that deferral. All the affected jurisdictions, so most likely because you live in Harris County, you'll have multiple jurisdictions that are taxing you, like the city, most likely city of Houston or city of Humble or Bel Air, depending on where you fall, and a school district. And all of them would be notified, and that deferral will take in effect for all those jurisdictions as a collective. You can still make payments. So even if you do have a deferral and even if your account is not necessarily turned over to a law firm, you can still make payments on a regular basis. So your deadline is still January 31st. That deadline is not changing. It is still January 31st. But if you do not have the funds to pay that in full, you're more than welcome to keep making partial payments. If payment is made before taxes become delinquent, no penalty or interest will be assessed. A maximum of 5% interest for each year is the amount that we assess on deferred account. The deferral lasts as long as the person that got the deferral lives on that property. So as long as that person is living and they are at that property, that remains active and in effect. There is no penalty assessed on the taxes while under the tax deferral. So on a normal account, we do assess penalty and interest if it is delinquent, but if it is a deferred account, we do not assess penalty or interest on the account. It is just a 5% maximum for the full year that is on it. So so whoever is the next person that the property is heir to. So once that person passes or something happens to that property where that deferral is no longer active, the person that is getting that heirship over the property does have a little bit of time to pay that property with that discounted 5% maximum interest rate on it. And that is for 180 days. After that 180 days, all the discount that is added on the account does get removed off of it. So again, even if you don't have the full payment, to make that payment in full within the 180 days. If you can pay that balance down as much as you can, that would be wise. I think that's pretty much it on that part of it. If you do have any questions, again, you can always visit our website at hctax.net. We do have FAQs where, like, if you do have common questions there, most of them are answered there. You can give us a call at our customer service line, or you can send us an email to our email, which is kind of covered by the little thing, but it is tax.office@hctx.net. Okay, that's pretty much it for me.
Okay. All right, now we're gonna open it up for questions. There were a few that's been in the chat and then we're gonna get to a couple of the questions that we have for the folks that are here in our audience. How do you, Miss Lisa, this is for you. How do you know if a Todd is, and I know that some of these were answered in the chat, but some people don't look at the chat or can't see it. How do you know if a Todd is on a property?
TODs, to be valid, have to be filed in the county property records. So a person could go to the county property records and ask to see what's filed on that property. You can go to the Harris County Clerk's website, set up an account, and try to search for it. It is extremely difficult to use that website to search for deeds. But if they are public record, so anyone could go and look it up.
The property has been found on Todd. Is it easier to go downtown to look, or is that what you were just saying?
It's easier to go downtown. There's also the website that I mentioned before, that's texasfile.com, that you can pull up deed records online, and that's a lot easier to search.
Is that the link that you sent to me?
Yes.
Okay, all right. So I'll be sending out that link of where to go to look on there. Okay.
That's a much easier way to search for deeds. And it's also, I don't know if it's every county in Texas, but it's most counties in Texas.
Okay. Is a title and a deed the same thing?
No, a title is not a document. A title is your legal right to the property. A deed is the legal document that says that a person has ownership rights to the property.
Okay. Okay, Ms. Mabel answered the question about the appraisal value. I don't want to get into too many questions about protests, so we're going to be talking about that on April the 22nd. Okay, so that was her question about the time. If a couple is listed on a house deed, one spouse dies, then the surviving spouse can file for an affidavit of heirship. So can the surviving spouse also do a Todd?
Yeah, and I didn't want to answer that in the chat because I wanted to say what I think they're asking, but then if they want to unmute, they can ask more. So if you're the surviving spouse, you can do an affidavit of heirship to transfer the other spouse's share to you. Once you have done that, you can do a Todd. And the reason that is, you can't give away anything you don't own. So you want to make sure you have a clear title before you file a Todd.
What if it's been more than like 15 years or so since the spouse has passed?
That's a great time to do an affidavit of heirship.
Affidavit as opposed to the
There's
amendment of title?
no deadline on an affidavit of heirship. I have personally done them for people who died in the 1900s. There's absolutely no deadline for it. Now, please don't wait 100 years to transfer property, but you don't have a deadline for an affidavit of heirship. It's a lot less expensive than going to court, and it's you don't have to have an attorney.
When would you do a muniment of the title as opposed to an affidavit of heirship?
You would do a muniment of title if there was a will. And
if there was.
Yeah, there has to be a will to do a muniment of title.
So that explains that. Okay. All right, Miss.
And I want to bring up something real quick because I am so glad that Mabel and Angela mentioned this. HCAD and the tax office have excellent websites. They are very useful. I use them all the time to look things up. When I'm teaching other people how to do different types of documents, it is a great way to educate yourself.
And the links to those videos that they have are going to be also on the email that I sent out as well. So
Great.
they'll be there. Yes, ma'am.
Except for the house in now, my husband just passed. Do I have to probate the will, or can I do an affidavit of heirship and do a title on this property I'm in now?
If a spouse passes away, there's tons on other properties that they own together. If a spouse passes away, it's too late to do the Todd now since the spouse is now deceased.
Right.
Affidavit of heirship as opposed to probating a will.
If the only thing that she needs to transfer is the house, she can do an affidavit of heirship. What a lot of attorneys do is they file a copy of the will with the affidavit of heirship. One thing that I had not mentioned in my presentation that's a good thing to know. Most of the time, almost all of the time that I have helped people with affidavits of heirship, they did not want to sell the house. They wanted to keep it in the family. If you want to sell a house, you should talk to a title company before transferring it with an affidavit of heirship, because some title companies want the affidavit of heirship to be on file with the county clerk for 5 years. That is no big deal if you're just planning on living in the house, but if it's something where you want to sell the house, and fairly soon, it's a good idea to talk to your title company first.
How does that work when it comes to surviving spouse that only had that the person that's deceased had credit card bills, say for instance, only in their name?
Then
How does
that
that
is
impact the spouse?
if that's truly separate debt, they cannot go after the surviving spouse. They will seek to get collection from the deceased person's estate.
That was a lot of that is a lot of yes, ma'am. Yes, ma'am.
There's no will.
Mm-hmm.
And so we filed an affidavit of heirship for one of the siblings,
Mm-hmm.
but our names are still there. It's still on.
Like their share.
Yeah. Okay, as far as the dish, I think does, can she just take part of that because we're all over 65? I mean,
Who's living in the house?
She's 60, but we're all over 65. So she's been in the house now for 12 years.
Okay. So, Miss Mabel, okay, Miss Mabel, can you briefly go over again heirship exemptions and how that works? Because you've got multiple siblings that own property, or that own a property together. One is under the age of 65 that actually lives there. The remaining siblings are over the age of 65.
It's gonna depend on if that person is living there, then they may not be eligible for the over 65. They would be eligible for the general resident homestead exemption, but there might be some cloudiness there, so I would recommend that they, in terms of who all is living in the house, so I would recommend that they give our exemptions department a call, because if someone who is over 65 is living in the house, is also heir, that may be how the transaction, that may be the person that needs to lead the transaction. But whoever's living there, but whoever applies for it, it's going to be based on their eligibility. So I would just say if they have some questions about that, give us a call and ask to speak to an exemption specialist. And they may be able to provide you with some sort of alternative approach. If that makes sense. Can you hear me?
Yes, yes, ma'am.
You look like you got a question on that.
I just want to make sure she's good with the
Okay.
explanation. So that's why I'm like.
Typically, because if she's submitting it, her driver's license is going to show her age, and then the exemption is going to be based on her eligibility for the general resident homestead exemption and not the over 65.
Yeah. So you guys can't get an over 65 exemption because you're not living there.
And keep in mind, then obviously if they're living somewhere else, they probably already have that over 65 exemption on their property.
On their own. Yes, they do. Yeah, you can't have it on multiple. Okay. Miss Carol? Okay. Miss Carol?
I have a question for Miss Lisa.
Okay, Miss Lisa, this is for you.
With regard to non-public assets,
Okay,
this would be a right to a life insurance policy where the recipients are deceased.
oh, the beneficiaries are deceased.
What an application is needing, or what type of application is needing to collect on the house.
If a person has a life insurance policies and the beneficiaries that they name are now deceased, the person who owned the policy, I'm assuming, is deceased as well. But the beneficiaries that they left the insurance policy to are now also deceased. What happens to the life insurance policy itself?
It has to be resolved through probate court.
Is there a fee for that?
Yeah, you have to get it, yes.
This
Yeah.
is why I tell everybody you should revisit your beneficiaries about every 5 years or so. People get married, people get divorced, people pass away. Lots of times, someone meant to put beneficiaries in place, but they pass. So you want to, check your accounts about every 5 years to make sure it's still the current legal name.
What happens if they transfer the policy to the state? Still got no probate?
You see, if the policy has already been transferred over to the state, it still goes to
The policy is in the estate account?
to the state. The
Oh,
state.
to the state? Oh, then it doesn't go to probate court?
As
There's a different process.
unclaimed. It's unclaimed benefits now, or unclaimed proceeds.
I don't know very much about that process, but a family member, I think you would have to prove that you are the person legally entitled to it. But you would not have to go to probate court then. You would be going through the unclaimed property office.
Did you hear that part? Okay. All right. You had a question. Mm-hmm.
So if they're like surviving spots, maybe it's the brother that passes away. Okay.
Okay.
And his wife is still living in the home. But he also has siblings, like 3 or 4 siblings out there. Okay, so everybody's got their portion. That spouse is not deciding to be here. She's just living there and she's paying tax. If the brother was over 65, would she be entitled to a discount in the exemption?
Okay. So we got a life estate where a brother, a sibling, make sure I get this right. Okay. Someone who was one of the heirs in a property had a spouse. The heir passed away, but the spouse is still living there. So she has the life estate because she gets to live there, but she's paying the taxes. If the brother was over 65, the decedent was over 65 and the spouse is still living there, is the spouse able to get the over 65 because she's under 65.
This is more a Mabel question, but I believe if she's over 55, she is.
Yeah, I believe so too. Again, because it's a life estate and there's some there may be some issues attached with the life estate that she would give our
Specialist.
exemptions department, give us a call to just to be sure, but it sounds like she would be eligible under the surviving spouse exemption. But because it's a life estate, I just called to be sure.
Okay. If there are deferred property taxes, Angela, on a property, how do you find out how much that's still left to be owed?
You can give us a call because sometimes if it's like a deferred account, it might not be posted online for, just in case if it's over 65 account, but you can give us a call.
And if I may interject, Nia, do we need to go into specifically talking about the difference between the deferral
Yes,
as well as
yes,
over 65 for a group,
yes,
just to make sure?
yes, please.
Okay, so we often find that there's some confusion among homeowners as it relates to the over 65 exemption as opposed to the tax deferral. Number one, when you're going to if you're going to do a tax deferral, it's important to remember that you are deferring or postponing your taxes. And Anjala, feel free to jump in anytime. And that those taxes are being deferred, they're being postponed, they're being delayed. They're going to be due upon the death of the current owner because, again, that was an exemption privilege that they had. You are no longer eligible for it. And as Angela mentioned, you have until 180 days. The person inheriting the property will have up to 180 days to pay that before they're facing the full interest and penalty charges that you might have had that deferral not been on the property for that amount of time. Now, a lot of times, depending now in the over 65 exemption, I mentioned that you get a $200,000 exemption for school taxes. You would get something in the neighborhood of, I forget the exact amount, something in the neighborhood of 325,000 for county, and the school district, and the city offers a similar amount. So you may have some people.
320 for the county.
How much is it?
320.
320, right? So you get something over 300,000 for both of them. I forget the exact numbers, but 320 for the county. Keep in mind that for some folks, if they've been living in property where the value is less than that, then they may have been paying no taxes at all because their exemptions exceeded the value of the property. This kind of gets mixed up in the neighborhood drumbeat about so-and-so doesn't pay any taxes, or
They just assume I'm over 65. I don't have no taxes
I
to
don't
pay.
have no taxes. But it
Yes.
depends on the value of the home. And
Mhm.
it also depends on, and it also important, if the homeowner hasn't discussed the deferral with their heirs,
Years.
they may assume that they weren't paying taxes because they were over 65. Keep in mind that there's a difference and that you definitely want to find out whether it's because of deferred taxes or because of the over 65. Either way, you're going to have to make some changes to that account to so that you're not underpaying or maybe over.
So for the people that does not pay any taxes, if they have a $0 account, the tax office does send a bill. Even if they pay nothing, we do send a bill that's a $0. And if it is a deferred account that still have taxes owed, they're still getting all the delinquent notice because technically their account is delinquent. It's just we're not collecting on it. So their deadline is still technically January 31st. That's when they can pay without having any penalty or interest assessed on the account. But after that January 31st, it's an annual 5% that we assess on it. But again, they will still get notification. They will still get reminders from us letting them know, hey, there's still a balance out there. You don't have to necessarily pay it, but it's still there.
So it's a good
So
idea if you're over
makes sense.
65, have a tax deferral, have the conversation with your heirs, your relatives, whomever, to let them know, hey, I'm getting a deferral. So when I'm gone, y'all got all these taxes that need to be paid. So do you want to start paying them now or do you want to wait till later? But yes, you can make payments even if you have a deferral. The deferral is just a safety net. A lot of seniors, when they get older, they're on fixed income, they're on a limited income. So they may not be able to pay property taxes versus paying for medication or what have you. And that's perfectly fine, but it's that safety net that's there for the over 65. But yes, you can most definitely pay the taxes when you have a deferral. Yes.
And if you know that you're going to be inheriting a home from an older relative, you can go ahead and make payments. I mean, even if
Yes.
they're minimal payments, that helps,
Yes,
any little bit.
we'll take anything. Honestly, like if you only have $10 to make on it, you can.
And let me say this, property taxes are gifts. So your property tax bill can be paid by
We'll take that
anybody. Does
$10,
not
even if it's not
entitle them
paying it
to
in full.
ownership interest in anything, just because you're making the payment.
Correct.
So all those
Yes.
things people see on TikTok and the street committees buying tax certificates and all that, showing up at the hotel, and we can show you how to get good lunch and tell you how to buy, you get property tax, by paying somebody's property taxes and you get these properties. They don't do that in Texas. So just so you know, I'm telling you, because we get that all the time.
And finally, there's just one other thing, if I could add, for those of you who, I'm sure our audience here kind of knows the difference, but sometimes you may run across people who are very confused about what the over 65 exemption means. The over
Yes.
65 exemption, which gives you that discount, as we've talked about, it is a discount that is provided to that person, that qualified person who is receiving it. It is not something that has to be paid back like the deferral. But we hear we've heard a number of seniors that will say, I don't want that over 65 exemption because I don't want my kids to have to pay it back. If you hear them say that, they are referring to the deferral and not the over 65. That is their discount to have. So if you can help clarify that with folks,
Please.
great.
We have another comment. Question.
Just so you know, make sure that you're over 65, only on your homestead property. If you have multiple properties, you turn 65, you owe taxes on everything else outside.
He's making a he's making a comment about the over 65 only applying to your resident homestead. If you have investment properties, you still pay the regular tax bill, the full taxes on those. It's only for your resident homestead. Yes, ma'am. Mm-hmm.
When should she be assuming responsibility for those taxes?
As soon as now. Yeah. The question was that someone passed away last year. When should the heirs assume responsibility for the taxes after someone passes?
As soon as possible.
As soon as possible. This year.
Yes.
Okay. So were the taxes for this year already, for 2025 already paid? He didn't owe anything. Okay. So when did they pass last year? Okay, so if a property owner passed last year, the tax did not owe property taxes because of the age and the value of the house. So now 2026 is here. Is this the year that the property needs to be in their name and that the exemption that was available is now gone?
Yes. Remember, January the 1st.
January the 1st.
The magic date and we've passed it so this year's taxes are going to be based on the current owner's exemption eligibility.
But she got regular homestead exemption.
Is apply for the home, even though they're not be all tired out.
She still applies for the homestead exemption.
Yeah.
Yes.
No.
No, there was a question about finding out how do you find out how much is owed? As Angela had mentioned, contact the tax office directly because what may be owed is not necessarily what's actually on the statement that's online. And mhm. What does an over 65, 100% disabled surviving spouse need in order to continue of a veteran? 100% disabled veteran, the surviving spouse. What's needed from the spouse for the taxes?
For the taxes, if their name is on the deed, they may not need anything, but I would call our exemptions department to make sure that the way the account is set up, that's eligible. Angela, you might also want to add something to that.
Yeah, so as long as the name, like she said, like the name is on it, you just have to go to HCAT and do the surviving spouse thing, and it should just carry over. And you just need the letter. If the spouse had the 100% exemption letter from the VA, like, that's your proof right there. And as long as you're over the age of 55, you should be able to get it. But you do have to transfer that exemption because you're no longer technically a veteran, you're a surviving spouse veteran.
Ms. Mabel, do you know if we're gonna have an exemption specialist available on the April 22nd presentation?
Yep.
Okay, so April 22nd is the property tax rep that's on via Zoom. But you have the list of where they're gonna be for all of their other presentations in case you guys wanna show up in person somewhere, if you have other questions about your property taxes and the bills and things like that. So, but we will be back via Zoom specifically for the property tax presentation on April the 22nd. Yes, sir.
Even if you always think and if you're living in a house with an old guy, you don't have tax, I would suggest you fight that.
Oh, yeah, well, we definitely, we didn't want to get into too much of a protest conversation before we get into making sure that there's probate. Is there a way to search if I'm for Harris County or outside of Harris County to do a search for a property record and when you're not sure where the property is actually located?
I know it.
I don't know. That's a great question. Because
Yeah.
I know there's like Katy is 3 or 4 different counties.
You may have to search each and every county that you think it may be in. I don't know if there's a statewide.
No, there isn't
The
because they
Texas
all
Online
have,
is statewide, but if I remember correctly, I haven't looked at the website in about a month. If I remember correctly, you still had to search by county.
And we're talking about register of deeds, not the property tax bills. We're talking about the actual property itself for the deeds.
I think you would still, I'll take a look at the website right now, but I think you still need to search by county.
Okay. All right, she's gonna verify. Yes, ma'am. You have to pay to open title though, when you're usually doing a property search with title company. Yeah, you can. Someone made the comment about using a title company to do a title search. You could pay a title company to open title for a property search as well if you're interested in selling or trying to do whatever it is that you need to do to it. Should a will be probated and if the estate is considered solvent?
I would talk to an attorney about it if you're able to, but probably not. I don't see that there would be any point for it.
Okay.
Okay, I'm sorry, I said the wrong website. It's texasfile.com.
I have the link for that one.
They have a statewide search.
It's a statewide search for that one. I
So
have the
Texas-
link for that one.
I'm sure you do, but I'm going to put it in the chat real quick.
Okay. Are there any, everybody's kind of leaving. I just wanted to make sure I got everybody's question real quick before that's about it. All right. There was one thing when it comes to the eligibility for benefits, as far as federal benefits, when it comes to disasters, things like that. When you guys, not you specifically, but as you're trying to clear title and you've got multiple heirs that actually own a property or have ownership interest in the property, you potentially are disqualifying yourself for those benefits because they look at all of the owners listed on the deed, all of your assets, all of your income for all owners. So if you've got 3, 4, 5 siblings that are all owners on one property, you're not eligible for those assistance or those benefits for those programs because they consider all of the income for all the owners. So that's a problem that people tend to create a lot of times too, when you're naming multiple owners in like a Todd or something like that. Don't cause that confusion as it relates to wanting to sell property or something and you've got all 5, 6, 7, whoever in charge and have to make that decision. Ms. Lisa, do you want to touch on the importance of still why you need to have a will then at that point?
We really don't recommend that you have more than 1 or 2 beneficiaries to a house. The reason is, like Neil was just explaining, if there's a disaster and you're applying for help to get the roof fixed or whatever repaired, if there's 5, 6 beneficiaries and you add up all those incomes, you might not qualify anymore because the incomes would be higher. Another issue with shared ownership is if one person wants to sell the house, they can go to a judge and get the judge to order that the property is sold. I know, and I understand that it's really important to your house is your most valuable asset. You want all of your children to share equally. It gets really complicated when you have multiple heirs.
Okay. All right. Thank you so much, Miss Lisa, Miss Mabel, Miss Angela. Sincerely appreciate you guys for showing up this afternoon and being able to provide this information to the community. The links, all the resources, all the services that you guys have mentioned will all be going out in an email. A copy of the recording will go out to you as well. A copy of the affidavit of heirship form and what's the affidavit of death form when it relates to the Todd. All of that will be emailed out to everyone. So if you didn't get to see it or review it or what have you, then don't worry about that. Also invite you, like I said, to definitely come back and join us on April the 22nd for our property tax, talking about the protests, valuation notices that have gone out, the payment options and calculating the tax bill. All of that's going to be discussed in a little bit more detail on April the 22nd. So invite y'all to come back for that. So thank y'all very much this afternoon. I know we are 15 minutes over. I definitely want to be mindful of your time. We appreciate you guys. Thank everybody for joining us this afternoon. And hopefully we will see y'all next time. Take care of yourself and stay safe.